Let's get to our first guest. As the SEC launches wide-ranging suits against crypto's biggest player, what could happen next? Our first guest, Michael Selig, Asset Management Counsel at Willkie Farr Gallagher, is here to weigh in. Welcome, Mike.
Hey, good to be here.
All right. You recently told CoinDesk that if you want to understand the agency's views on crypto, then these are the complaints to read. What are the big points that others in the industry should be taking note of moving forward?
Yeah, the Coinbase and Binance actions are really the culmination of everything that's come before. We're not seeing a whole lot of new allegations by the SEC, but we're seeing really everything that's been thrown at market participants in the past. So we're seeing illegal offerings of unregistered securities. We're seeing a failure to register as a national securities exchange, as a broker-dealer, as a clearing agency. And we're seeing allegations related to staking programs, earn programs. So really everything that we've seen over the past 5 or 6 years has been leveled against Coinbase and Binance. And the real distinction between these two actions, although the SEC might be trying to conflate them and bringing them the same week, is that there are allegations of fraud in the Binance action. And in the Coinbase action, we only have pure violations of the securities laws, where the SEC is alleging that Coinbase is offering illegal products, failing to register those products, and engaging in activities that are intermediary activities that are required to be registered with the SEC, but there's no allegations of fraud or wrongdoing. And so that really is what distinguishes these two actions. There are a few interesting new allegations in these complaints. Specifically in Binance, we see the first time the SEC is really taking the view that a dollar-backed stablecoin, and in particular one issued by a New York limited purpose trust company, so a company that's regulated by the New York Department of Financial Services, the SEC is saying that this stablecoin product, BUSD, is actually a security, which is an odd allegation and not necessarily a strong one, given that people are buying BUSD not necessarily to expect profits based on an increase in price, as they might with Bitcoin or Ether or other types of crypto assets. They're buying it expecting that it's going to stay at $1. And the allegation really pertains to Binance's pooling of deposits and use of those deposits to kind of offer yield programs within the Binance ecosystem. So that's an interesting new allegation. And then in Coinbase, there's this allegation that the wallet product, so an unhosted Coinbase wallet product, is actually broker-dealer activity, which we've just not seen in any case before.
So which case do you think has more of an effect, a long-term effect on the crypto markets? I mean, you brought up this whole stablecoin aspect to the Binance case. And then also, obviously, as you said, Coinbase is not a fraud case. It's a case of securities dealing, essentially, as is the same situation with Binance. But given that you do have the stablecoin aspect to it, which case do you think has a more long-term effect on the crypto markets?
Yeah, I think the Coinbase case is really the case to watch, because these are pure securities law violations, and it really covers the waterfront of all the key issues. So what is a security? How should we interpret the Howey test to cover certain of these crypto assets? And if you look at the assets alleged to be securities in that action, it really covers everything. It doesn't cover any stable coins. And I actually do think that's noteworthy, because Coinbase offers, in connection with Circle, the USDC product on its platform, which is a dollar-backed stablecoin. So it's worth noting that BUSD is alleged to be a security in the Binance action, but USDC is not in the Coinbase action. But putting that aside, I think the key issues are all covered in Coinbase, whereas Binance is more likely to get muddled by some of these fraud allegations.
It seems to me that it's more like Coinbase, it has more implications for American investors. Binance has implications, obviously, for the world, but there's a limit to what the SEC can do to Binance outside of the United States. But I guess just for Coinbase, are American investors, is their money safe on Coinbase? I mean, there are definitely some people out there, and not a lot, but there's a few loud voices on Twitter, et cetera, saying, get your assets off this platform. I mean, is there any world in which assets are not safe on Coinbase due to this kind of uncertainty?
Well, it's interesting because the SEC allowed the S1 of Coinbase to be go effective, and so there's kind of that imprimatur that this is a safe product for people to invest in, potentially, and to be using as a platform. And the U.S. government, in fact, sells and buys Bitcoin on that platform. And so, I wouldn't go so far as to say that it's not a safe platform. There's been no attempt to kind of freeze transactions on the platform. Really, the SEC's position is that certain of the products offered by Coinbase are securities and must be registered with the SEC, and therefore Coinbase, for its intermediary activities, is also required to register. So I wouldn't say that there's any allegations that it's an unsafe platform.
Just quick follow-up on that. So first of all, I know this is a big part of Coinbase's argument, right? That they kind of were allowed to operate by the SEC. But I mean, if you actually look at Coinbase's documents in the S1, they say actually very clearly that there's some risk here and that like some of the tokens could be designated as securities. So I feel like that argument is, I don't know. I mean, it was very clear from the onset that this could happen, and Coinbase itself stated it in its documents for an IPO. But putting that aside, what I mean about not safe, is there a world in which that, there's some panic, right? And then everybody there's like a so-called run on the bank, which we've seen in crypto quite a few times, right? Where everybody just sort of like, takes their assets off of Coinbase. Coinbase obviously doesn't have FDIC. Like, is there a world, I mean, I know this is a little bit extreme, but there are people kind of warning about this kind of thing. Is there any world in which that could happen?
I mean, certainly anything can happen in the crypto world, but I think today there's no really cause for panic that the SEC action is going to bring down Coinbase in that way.
More than a dozen tokens projects were mentioned in between these two lawsuits. As counsel who deals with the SEC, what kind of advice would you give to the projects that were mentioned as securities in these lawsuits?
Look, it's a tricky position to be in because the SEC is naming all of these different projects throughout. It's been doing this for several years now, naming projects in actions against unaffiliated third parties. And these projects, many of them take the view that the tokens that they issued many years ago, while at the time maybe they were securities, as if you read the Hinman speech, Bill Hinman, previous director of corporation finance, said Ether may have been a security when issued, but many of them take the view that today these networks are sufficiently decentralized and there's applications built on top. There's unique wallet addresses. There's all sorts of use cases for these tokens, and the teams have kind of moved away and become more adjacent developers on the networks. And so they take the view that these are non-securities and that they're not really operating or running these projects. And so some of these projects that may be inclined to step up and intervene in some way are going to find themselves potentially in a tougher position when they're trying to make arguments around decentralization. So it's a little bit of a bind, and I think that's the tricky position that the SEC kind of wants potentially to achieve, where the exchanges are kind of in this position of defending these projects, but don't have access to all the information they might need to do so.
So what advice would you give to any one of those token projects?
Well, it's really a tricky situation. I mean, I think you have to weigh the pros and cons. Whether you can trust Coinbase and Binance and others to defend, the non-security status of your token, which there's no reason necessarily to feel that their legal teams aren't competent and able to do so. So it's a tricky position. I think some might have unique reasons to intervene if they determine that Coinbase or Binance is not going to be able to put up the defense that they'd want. But generally speaking, I think it's wise for these teams to not intervene.
We had this situation with Willkie recently and the CFTC, and what does it mean in general? We have the SEC ruling certain things are securities. We have Willkie and the CFTC saying they're unregistered commodities. Stepping back a bit and looking at the bigger picture, what does it mean for this kind of conflict between the SEC and the CFTC, that we have these two cases? Is it getting resolved in the courts, or do you see it continuing?
I think ultimately all of this is going to have to be resolved by Congress. So we need clear legislation that really divides the jurisdiction between the two agencies. And this is really the same sort of issue we had in 2008 that gave rise to Dodd-Frank. There are certain products that really make sense should be regulated by the SEC, and there are other products that really fit within the CFTC's regulatory jurisdiction. And today, the CFTC only has true regulatory authority over derivatives markets. It has very limited anti-fraud authority over the spot markets, and so really legislation is needed to carve out the CFTC's jurisdiction. But that said, the CFTC is desirous of kind of defending the non-security status of certain assets, so it can maintain the position that those assets should be assets regulated by the CFTC if and when it gets that spot authority. And I think what you're seeing in Chair Benham of the CFTC is a position that certain of these layer one assets like Bitcoin, Ether, and then many of the stable coins like USDC and USDT should not fall within the SEC's jurisdiction because they're sufficiently decentralized or they have a dollar stable value, and so there shouldn't be an expectation of profits. And then there are all of these edge assets around different decentralized protocols, and you're going to have to put them somewhere on the axis between security status and non-security status. We've not seen the chair of the CFTC take a stronger view that certain DeFi protocol tokens, for example, are non-securities. I think the UkiDAO action was really the CFTC laying a stake in the ground and saying there are certain obligations of certain platforms that need to be registered with the CFTC, and it's not going to allow them to kind of do an end run around those registration requirements through a DAO.
I think what you're saying makes a lot of sense, that Congress needs to come in and untangle this. A bunch of people are saying that in different forms. But I think the question is like, what are the chances of that happening, say, like, I don't know, in our lifetimes? Because I just don't see any momentum whatsoever. I mean, we can't even get a basic stablecoin legislation passed. There's bills, so this, what you're talking about makes a lot of sense, but it's also really complicated. And there's no consensus in Congress about how it would be done. And there's no consensus in Congress that this even needs to be done. I think, like the crypto world is all like, oh no, crypto is going to leave the U.S. And I think a lot of people in Congress are like, don't let the door hit you all the way out. So what would it take for Congress? I mean, it makes sense, like, theoretically, but I mean, honestly, like, real talk, like, do you see any chance of Congress doing anything remotely soon?
I think every time the SEC sues another one of these crypto businesses that has tried to comply with the laws and regulations on the books, it puts more pressure on Congress to act, because you have businesses that are attempting to comply with the laws and regulations that really are not at all designed to accommodate crypto assets. So it's not an easy task to try and come in and look at registration requirements and reporting requirements and disclosures and import that all to a crypto asset world. Not to mention when you get into kind of exchange trading and peer-to-peer trading and all of that, it's really complicated. The market structure for securities is not built for crypto assets. So you have to give everybody a star for trying to comply. But Congress is understanding of this, and I think the more pressure, the more that the SEC is trying to regulate by enforcement rather than through rules, really puts pressure on Congress to say, okay, like, we need to come up with a structure that works here, and whether it goes to the SEC or the CFTC, that's for Congress to decide. But there needs to be some forcing function, because otherwise the SEC is just not willing to issue these rules. So I think if the SEC were to say, we're going to go issue rules, there would be a lot more interest in kind of complying with those rules and not really pressuring Congress to go do a whole new legislative package. But in this world, I think the pressure is growing. There are many that are becoming single issue voters. There are many that are raising funds to go, push for this bill. And I think it's possible. It's going to be a hard uphill fight just because of the political pressure to do other things and kind of this interest, among certain in Congress that we should just not legitimize this asset class. But I think we're seeing every day the UK, Europe, Hong Kong, China, all of these foreign countries adopting at least some form of law and regulation that can be complied with by companies that are willing to do so.
All right. And lastly, you mentioned the Hinman documents earlier on in this interview. They were released today in the Ripple case. Tell us about what that means for the Ripple case and what that could mean for some of these other cases that we've been talking about.
Yeah, so these Hinman documents relate to a speech that former director of CorpFin at the SEC, Bill Hinman, gave several years ago. And in that speech, Hinman articulated this idea that you could have a non-security that morphs or transforms into, a security that morphs or transforms into a non-security over time, really based on the decentralization of the network, among other factors. And in particular, Hinman mentioned Ether and said that Ether might have been issued as a security through its initial ICO, but over the years, we've seen so many new users on the network, so many new applications, so many different kind of node operators developing on the network and others. And so it's really this decentralized proposition, very much like a wheat market or other commodity markets. And so it's a non-security today. Now that speech has been cast into doubt potentially by the current administration, with the chair saying that every crypto asset aside from Bitcoin is a security. But this speech really shows that the staff, especially in the Office of General Counsel, as well as in former Chair Clayton's office, amongst other senior staff, reviewed that speech, took the view that this could make it very difficult to later take the view that certain crypto assets are non-securities, in particular Ether, given that this is kind of a staff view, and still allowed the speech to go forward. So it really shows a broader staff consensus around this potential view, although, of course, that staff can change, the administration can change. I think in terms of Ether, it makes it very difficult for the SEC to later take the view it's a non-secure, that it's a security. With respect to Ripple, it's not as clear because Ripple's arguments are not entirely focused on this decentralization position. They're focused on other prongs of the Howey test in particular, I mean, amongst all of them, but a lot of the points relate to Ripple not performing an ICO or a sale of the token initially, and conducting fundraising. So it's hard to say how important these documents will be ultimately. I think they add a little bit of support to the view that the SEC did not take the view that everything is a security at the time, but it's hard to say, they're not really passing on the specifics of the Howey test, more so this SEC policy that, can change with the wind.
All right, Mike, we're going to have to leave it there. Thank you very much for joining us this morning.
Thank you.
That was Michael Selig, Asset Management Counsel at Willkie Farr and Gallagher.